coming. I think we should start now. I will start by thanking everyone for coming and Salilo for giving this talk on part of the topic for the PhD. It's been very easy with the archival, working at the archive, the National Archive of Cambodia now. And briefly on Sally. Sally is a PhD student, as you can see here. She's now working towards a PhD at the University of Melbourne. And she's very much interested on the history of the legal systems in Cambodia, especially the modern one during the French colonial period. And she will introduce more on the topics, and hopefully you will have very good discussion on this topic. And on the logistics side, I just want to let you know that we have some waters at the back, so in case you refresh. Yeah, and small refreshments up there in case you want to grab it. Please do that. And now I want to give the floor to Charlotte.
CKS for inviting me and organising the evening. It's quite a privilege to come and make a presentation at CKS. Yes, as Mr. Swag said, what I'm talking about tonight is based on part of my research, my PhD research, looking at the impact of the legal system that was developed in Cambodia during the time of the French Protectorate. So my general thesis is about the impact and legacy of the changes to the Cambodian courts and law during the time of the French Protectorate, and I'm mainly focusing on the 20th century, so the period, say, from 1904 up until 1954. What I'm going to talk about tonight is very much a work in progress, so I'd welcome comments and suggestions, but please don't be too hard on me. Anyway, these pictures were taken in Posat in 1896, and in the main picture in the back row, from left to right, we have the interpreter, the resident, Mr. Erdrich, the governor of Posat, Mr. Sur, his oldest son, and then in the front row there are various officials, and the man on the left in the front row is Judge Spray, and that's his picture inserted up at the top. And I thought this was an interesting photograph because the courts, as they existed at that time in the provinces of Cambodia, were dominated by the governor of the province, and the judges, or I think they were called Sopia at that time, were of secondary importance in the courts. The governor was what the French would call the president of the local courts. So, before I start talking about the substance of this evening, I want to talk a little bit about some of the theoretical debates that frame my research. So, European colonisation was carried out basically for the benefit of the European colonisers. But it was justified in the minds of Europeans, you could very simply say, by their almost unquestioned assumption that the European civilization was more advanced than the civilizations that they were colonizing. And after many countries gained independence, there was a lot of debate about the role of colonisation and its impact. And one of the fairly mainstream interpretations was that colonisation, yes, it was quite exploitative and quite brutal in some countries, but it did bring some advances, some modernity, I guess is the way people sometimes talk about it. Or you could bring it down to roads, laws, courts, and institutions of a modern nation state, as well as economic development, although sometimes that was quite skewed as a result of colonisation. And then post-colonial scholars who emerged mainly in India started to critique this idea and say, well, did Western imposed modernity really benefit our countries? And some post-colonial legal historians, if you like, have talked about the idea that really the laws and the institutions that were imposed or developed by colonial powers were laws and institutions aimed at ensuring colonial domination. They weren't really the laws and institutions that were necessarily suited to the colonised countries and that were necessarily going to help them to move forward to a just and more democratic society after independence. And then there are also theories amongst comparative law that questions whether or not it's possible to transplant legal institutions, including laws, from one culture to another. Law in France, for example, is very much a product of French history, and so is it therefore appropriate to transplant it here to Cambodia, albeit in a sort of a modified way. And there's another theory posed by Sophia Ng. Has anyone read Sophia Ng's book? She wrote a history of the medical service in Cambodia during the time of the French Protectorate. And she talks about this idea of cultural insolubility. And the way I understand that is that as far as medicine goes, the outlook or the idea of what medicine was for Cambodians and the idea of what medicine was for the French medical services were sometimes so different that they were completely incomprehensible to each other. And so that two spheres or two ideas of medicine existed alongside each other. Sometimes they mixed, but sometimes they didn't. And that's simplifying it a little bit, but I think this idea of cultural insolubility may also be applicable to ideas of law, because the concept of law that the French brought with them was so very different, I think, to the concept of law that existed here in Cambodia before the French arrived. So, the topic of my talk, or what I'm talking about tonight, is how the French brought about the separation of powers in Cambodia. So I just wanted to know, it's a sort of a concept that lawyers toss around a lot, and I just wanted to know if people here have an idea of what separation of powers means. It means it's slightly different between different legal cultures. So the civil law, French civil law system has a slightly different idea than the common law, Anglo common law countries like the one I come from. But if you want to put it in a nutshell, you could say that judges are only judges, and they don't get involved in other parts of the administration or other parts of government. And similarly, other parts of government don't get involved in, particularly in court cases. So I think, particularly for tonight, that's a good enough definition of separation of powers. But if anyone wants to ask me questions as we go along, please do. Okay, so When the French arrived in Cambodia when the Protectorate was established in 1863, there were quite a few people who started to try to study Cambodian law as it existed at that time, and they read the old Quran and they talked to learned Cambodians, and based on those observations, they claim that this was how the courts or how justice was administered, or meant to have been administered in Cambodia at the time that the French arrived. And the most outstanding thing that you can see about it is that at the very top of everything stood the king. He was meant to have been the supreme judge of the land and also the supreme lawmaker of the land. But the French said, and this was partly, I think, to justify their intervention and to try to change this system, they said that actually this was a system on paper only and that it didn't work like that in practice anymore. They said that the system had degenerated and that just about any official in the country could act as a judge, and that they liked very much to act as judges because that way they could extort a lot of money from the people. And there's a famous quote, I think, by one of the early French observers who paints a picture of Cambodian judges being very corrupt and very arrogant, sitting around talking about other things in the middle of the hearings, prolonging the hearings for as long as they can so that they can get as much money out of the litigants as they can. So the French said, okay, this system may have been okay on paper, but it was no longer working, and it was in their eyes, it was a very corrupt system. So up until during the reign of King Norodom, they did make some changes to Cambodian courts and laws. In 1884, they forced King Norodom to sign a treaty saying that the French could make as many regulations as they liked about Cambodian law. And although they couldn't actually put that into practice for quite a while, they did gradually start wearing away at King Norodom's power. And in 1897, as most of you know, they took control of the Council of Ministers. And from 1897 onwards, the Council of Ministers met under the chairmanship of the Resident Superior, the most senior French administrator in Cambodia. And the king didn't attend the meetings of the Council of Ministers. So he was gradually excluded from the day-to-day governing of the country, or the French tried to anyway, and he was also gradually excluded from any judicial role. He wrote this letter, King Norodom wrote this letter, and this is just extracts, to the French Resident Superior in 1898, I think it was. And he was really angry because the French had just removed two people who were very loyal to him. One of them was a judge called and one of them was the Minister of Justice called Uk. And because they retained a very close relationship with the king, the French removed them, and King Norodom was very upset about that. But you can also see from this quote that the French had set up their own courts, and they'd taken Vietnamese and Chinese people living in Cambodia were taken out of the Cambodian courts and they went to the French courts. So by the end of the 19th century, quite a few changes had been made to the way justice was administered. But the really big changes were to start after King Norodom's death. And the first step in this process culminated in 1911 when King Sisowath gave his approval to three new codes the État Civil, which is the first part of a civil code, a new criminal code, and a code of criminal investigation or criminal procedure and judicial organisation. Now these three codes were drafted by joint committees, and there were several attempts to get these drafts made. The first committee was established in 1897, I think, and then in 1901. But again, it wasn't until after King Norodom's death that the committees really started to work. And the ones that drafted these three laws sat from 1905 to 1911, and there were a lot of Cambodians involved in these committees, but each one was chaired by a French official or French judge, depending on who was available at the time. It's the third code, the Code of Criminal Instruction and Organisation, that reorganised the Cambodian courts, and is the most important for this story. So under that new code, which came into effect in 1912, they greatly simplified the court structure, as you can see, and established some new courts that had never existed before. So the one at the top, the Sala Vinichayi, was called a court of cassation, which I don't know if there are any lawyers in the room. It's like a very high court of appeal, and it only deals with issues of law rather than issues of fact. And several other courts, the Sala Court, a court of appeal, and in Phnom Penh, the Phnom Penh court was called the Sala Lampur, and out of the provinces, the Sala Khai. I should also note that at this stage there were 51 Khai in Cambodia, so there were 51 Sala Khai. And I think the Khai, as they were called then, is sort of similar to a district now, a strop. Many of the names are the names now of a strop or a commune. And they also tried to get the chief of commune to play a role in mediating small disputes, which proved quite unsuccessful, partly because most of the commune chiefs were illiterate at that stage. The setting up of the Sala Vinichayi was an important step towards the separation of powers, because up until that time, this High Court of Appeal had actually been, or the functions of that High Court of Appeal had actually been carried out by the Council of Ministers. And the Council of Ministers, the members of the Council of Ministers, many of whom were princes, were quite unhappy at this idea of having their judicial powers removed. I was reading some of the cases that they had decided just recently, and they were often cases about officials, disputes between different officials accusing each other of corruption or malpractice. And I think it was very important for the Council of Ministers that they should have the final say over these kinds of disputes. It gave them quite a bit of power still. So they were quite upset about the establishment of the Court of Cassation, or the Sala Vinichayi, but King Sisowath had given his approval to it. And so he was reasonably happy with it until 1914, because in 1914 the first president of the Sala Vinichayi, who had been a prince, Prince Madhavan, died. And the resident superior at that time, Mr. Baldwin, wanted to appoint another Cambodian, a man called Kep, to take his place. But Kep was not a prince. He knew quite a bit about law, and he'd been working very loyally for the French administration, and they had a lot of respect for him. So they wanted him to take over the presidency of the Sala Vinichayi. And this time King Sisowath was very upset. So he wrote to the Resident Superior, and he said that the previous Resident Superior had promised him that the president of the Sala Vinichayi should be a prince. And now Baldwin was going back on his word, back on that word, and as he said in his letter, that up until that time, the head of the highest court of the land had always been a prince, you're right? So this was a big, that Salah Viniche was a big change in two ways. First of all, it was no longer the Council of Ministers, who are the executive, who were making these decisions, but secondly, also the royalty were being removed from those roles, and the French were trying to give them to people who they thought were more capable and also completely loyal to them, of course. Just to go back here again to the Salah Kite, they were still headed by the provincial governments, so the separation of powers hadn't reached out into the provinces at that stage. And this was quite a problem for the French. The residents in the regions tried to supervise the decisions of these courts, but I think they had quite a bit of trouble. And it was also a big ask for those governors to apply all the new codes that had been enacted in 1912, because the French didn't actually have a very good system for training judges. They did try a little bit to train some of them in the new codes, but it was mainly done in Phnom Penh. So the Ministry of Justice used to just write circulars to these Tuai Kite or Tuai Strop, as they were called, and tell them, you must do this, you must do this. And I don't think that would ever have been a very effective way of getting the provincial governors to apply the new laws, even if they felt it was in their interests to do so. And one of the tests of the Salah Kite happened in 1916. Most of you probably know that in 1916 the French were taken by surprise when wave upon wave of people from around the countryside started coming to Phnom Penh and asking the king, camping outside the royal palace and asking the king for relief from taxes and corvée. Corvée was the forced labour that all Cambodians had to do for French public works, sometimes up to 90 days a year. And at this time, there were also around the countryside, according to some historians, what they call tax strikes. That is, people just stopped paying their taxes. And in some regions, also there were riots. People started, in some cases, attacking local officials who they thought were corrupt and had been exploiting them in the way they administered the corvée and the taxes on behalf of the French. So the French responded to this in three ways, in at least three ways. They brought in more soldiers to keep the peace, but they also made some changes to corvée, and they asked King Sisowath to declare an amnesty for the demonstrators if they would stop demonstrating. But they also promised that there would be trials and punishments for the ringleaders of the people who didn't stop protesting. One of the regions where the riots have been most violent or most intense was in the Irian region, which at that time was in Spiraling, or under the control of the resident of Spiraling. On February 12 of 1916, about 200 people surrounded the Salah Kite, and for the few days beforehand they had apparently been threatening to kill some of the local officials. So when they surrounded the Salah Kite, the people inside, the local officials, started shooting, and at least eight people were killed, as far as we can tell. But yet the very next month, on March the 13th, it was the same officials who'd been firing who actually sat in judgment over those people who were accused of rioting. And they tried and condemned 16 men for inciting rebellion. And I've read the translation of that judgment, and it's all about the judges, the officials of the Salah Kite trying to justify their actions in shooting the people, and were trying to make sure that the 16 men that they were condemning were, made out to have been conspiring to commit rebellion, particularly against the French. So you can see there the conflict of interest that existed in the Salah Kite. Now the French reacted. There was a lot of criticism of the way the Salah Kite all around the country carried out these trials. They were criticised for imposing very harsh punishments, and many of those punishments were reduced when they went on appeal. But the attitudes were quite mixed. So Resident Belan, who was in Spy-Reading, he thought that the Salah Kite had done a reasonable job. He said that they exercised all desirable impartiality, because I think he probably wanted to see peace restored in his region. So he didn't mind a bit of heavy-handedness on the part of the Salah Kite. On the other hand, Resident Superior Galwan was very conscious of how people in France and outside were viewing the treatment of these people. So he criticised Belan for allowing too many irregularities to happen in the courts. And this toing and froing went on for quite a while, and then King Sisowath started to get involved. He did a couple of things. He asked for leniency for some people who he described it as his clients who had been convicted. But he also advised Resident Superior Galwan to stop the trials. He said, look, the shootings were punishment enough, the riots are over, forget about the trials. And actually this is what Resident Galwan did eventually, just stop the trials. But the events of 1916 gave fresh impetus or fresh momentum to the French to continue reforming the courts. And so in 1922, there was another royal ordinance signed into effect that again reorganised the courts. And by this time, all of the courts were staffed by people who were meant to be professional judges. And another interesting thing that happened was that they set up the Salah Ukrep, which was the criminal court. And there was only one of these, and that was in Phnom Penh. So that meant that serious crimes from then on all went to Phnom Penh to be tried, which again allowed the French to have more control over these sorts of crimes. They didn't want a repetition of what had happened in the Salah Kite. The other interesting thing is that the Salah Kite themselves, the 51 Salah Kite, were abolished and replaced with, I think at first it was only 13 Salah Dambang, or courts of first instance. And around about that same time, the French also reorganised the administrative divisions in Cambodia, so that the what we now call a province looks much more like what it is today. So there were only 13 or 15 of them as opposed to 51 before. At the same time, they also pushed through the appointment of a French judge to work as technically as an advisor to the Minister of Justice. And he was called a conseiller juridique, and he came to have a lot of power. He actually had control over promotions of all judges. If they wanted to go on leave, they had to he had to approve them leaving their post even for 3 or 4 days to go leave there. And he also had the power to sit in on some of the more serious court cases and advise the judges on how they should rule. So, just to conclude, there's Article number 65 of the 1922 Ordinance re-emphasised the fact that the courts were now very much under French control. Technically, the French had that power since 1884, but they had gradually taken that power and exercised it. And the second quote comes from a manual for French administrators written by Mr. Sylvestre, I think in 1924. And he simply said in that manual that the Salah Kite had to be replaced because the French couldn't exert strong enough control over them. So, in conclusion, I guess what I'm trying to show with this story is that there were two sides to the separation of powers in Cambodia under the French. First, that you could argue, yes, it was necessary because it was good to have professional judges who were not also involved in administration, so that you had less conflict of interest in cases like those of 1916. But on the other hand, that went hand in hand with closer and closer control over the courts by the French. And so you could argue really were powers separated at all, because it poses the question of who really was the executive power in Cambodia. Was it the Cambodian Council of Ministers who had been pushed aside, or was it the French Protectorate Authority who were exercising quite close control over the courts? Anyway, thank you. I'll leave it at that, and if you have any questions or comments, that would be great.
Yes, ma'am.
I have one question, if you don't mind. Sorry, Lynn.
Sure.
What was, this is the administrative side of the reform, but how about, I mean, in order to enact it, you need to have some sort of what do you call that, building of the capacity to have judges, right? What sort of institutional reform was there to provide training? Because if this was part of the mission civiliatrice,
very little.
You know, so the educational process to build those slots.
Unfortunately, very little, and that's I think I did touch on that. But these new codes were enacted came into force in 1912, and the poor governors were expected to apply them. And the only training that existed for judges, as far as I know at that stage, was some part-time classes that were conducted by the French prosecutor at the local French court here in Phnom Penh. And the codes were, of course, translated into Khmer, but you know, if a governor received a big thick document like this on his desk, is he going to pour through it and study it and learn how to apply it? No. Later on, there was some training at the administrative school for judges, but there was no law school in Cambodia until after independence, and some people were sent to France or to Vietnam to get law degrees, but there weren't that many. So on the one hand, we did have this very formalistic approach to reforming things, but it wasn't always backed up by the resources, the human resource building that's needed. And if you read back, I often come across documents written by the French saying, you know, we have the perfect system now, and it works under our close supervision, and we're just waiting for the new generation of judges to come along who are really equipped to apply it and take it to heart. But as far as I can tell, that never happened.
So it was more or less on-the-job training, if you may.
Yes, on-the-job training. And I mean, they tried to, of course, if people had law degrees, then they were slotted into the judiciary. But, you know, I found a letter from the king written in the 1930s saying, here's a young man who's just come back from France and he's done the first half of his baccalaureate. I think he'd make a very good judge. And so he was slotted in somewhere or other into the judiciary. So I think they did a little bit of on-the-job training, but yeah, it was pretty sketchy. And even after independence, I think one of the big problems for the courts was a lack of qualified people, of course, until Royal University of Law, I forget what it was called then, started producing graduates.
So were they implementing French law, Cambodian law, or a mix?
Well, that's a good question. These first codes were said to be a codification of Cambodian law. But in fact, the criminal code, I think I forget, about more than 2/3 of the articles were actually based on French criminal law, because the French said, well, everywhere we found a gap, we draw on French law. But for them, of course, anything that wasn't French law was probably a gap. In areas of civil law, they did try to keep some, what they saw as Cambodian customs, so marriage and some things like that, they tried to maintain. But they also started to regulate it. What's the word for people who have more than one wife? That was regulated in polygamy. Yeah. It was allowed to continue, but it was quite restricted, and the French imposed their own interpretations of, who was the first wife and who was the second wife. That was involved in the codes. Yeah. So very much they just kept going further and further towards French substance, and certainly in areas of contract law or business law, of course, then French substance was introduced. They had a big problem with land. They tried to introduce. There was a dream to introduce a land law that was consistent over the whole of French Indochina. And Cambodia was a big stumbling block for them to do that. Partly because land was not a shortage, was not in short, at that stage was not in short supply. And the idea of usage right, if you had occupied and used land for 5 years, then you had the right to use it, was just very stubbornly ingrained in Cambodia, and the French couldn't really get rid of that. In the end, they kept it, and they kept saying, we'll reform it in the future. Yep.
Yeah, enjoying your talk very much.
Thank you.
So my question would be, to what extent what was going on in Cambodia coordinated what was going on in Vietnam, and in addition to Cambodian and French traditions and Vietnamese tradition at all, a factor of attention there, and at least my stereotype is that during the colonial period, a lot of French bureaucrats were brought to Cambodia to work. Were they in the judicial system as part of the dynamic at all? What was going on?
Yes, well, there were a lot of judges from the French Court of Appeal in Saigon would come across and work in Cambodia for a while.
But they were Vietnamese, whatever.
No, Vietnamese judges. Khmer Krom, like Son Ngoc Tan, I think he was a judge for a while. But not Vietnamese, no. It wasn't like in the other administrative areas, there weren't Vietnamese judges. They may have been a few Indian judges, because they were, they wouldn't have worked in the Cambodian courts. You see, there were two sets of courts existing in Cambodia all this time. There were the French courts, and so any case that involved a European or later a Vietnamese or a Chinese went to the French courts. And they imposed French law, although if you were Chinese or Vietnamese, they imposed what they thought to be Vietnamese law. And so the only people who went before the Cambodian courts that I've been talking about tonight were those considered to be real Cambodians.
And so was what was going on similar to what was going on in Vietnam, or was
that's the other part of your question. Yeah. There were attempts by the French to sort of create a unified system across Indochina, but it was difficult for them because the legal status of the colonies was different. Cochinchina was formally annexed; it was a formal colony, whereas the others were protectorates, but protectorates with various different forms in Laos and Cambodia. And also the way they interacted with the courts that existed, what they called indigenous courts, were quite different just depending on the contingencies of taking control. So in Tonkin, where there was much more outward resistance to French colonisation, they took control much quicker of the existing courts there. So, but here in Cambodia, apparently in 1884, they did consider just abolishing the Cambodian courts altogether. And I suspect probably because of the rebellion that followed the events of 1884, they realised they needed to be a little more gentle, and so they allowed the Cambodian courts to continue to exist, but set about trying to remodel them along French lines, and also to take as many people as they could out of the jurisdiction of the French courts and place them into the out of the jurisdiction of the Cambodian courts and place them into the jurisdiction of the French courts. Hence the Vietnamese and the Chinese were removed, which was also very upsetting to the king. That quote from King Sisowath refers to it.
When we're talking about this separation of power, administrative and judicial power, we talk about the Cambodian system. I wonder if, like, discussions on how was the concept of this separation of power was understood by the French themselves during that period.
Yes.
So that it do reflects that how they would treat the colonized systems.
Yes. It's probably something I should study more. Need to do more research about. I know that the idea of separation of powers evolved in French law a lot during the 20th century. And during the Third Republic, which is the time that we're talking about now, judges weren't very powerful. The courts and the judges were hardly even considered an arm of government like they are in America today, for example. You know, America, I guess, is the prime example of the three arms of government: the judiciary, the executive, and the legislature. But in France, for historical reasons, because of the reactionary role that judges had played before the revolution, ever since the French Revolution, there were attempts to keep judges quite subordinate to the other arms of government. That you could argue that evolved during the 20th century. But it's also a bit different to the Anglo systems that I'm used to, because the administrative side of law was kept separate from the other side of law. So complaints against the government were dealt with by separate courts, and also constitutional issues were dealt with by a separate body, which was considered not to be important at all. So whereas in my country, in America, the highest courts have the power to say that a law is unconstitutional. In France, that didn't happen. It was a separate body of people who weren't at this stage considered to be judges who had that power. I don't know if that answers your question. No. But yeah. So for them, it was at this stage very much a sort of, I call it an administrative measure, that there should be a separate judicial service and a separate administrative service. So cadre were recruited to the judicial service, and they stayed in that service. Yes.
In the 7th century, actually, there were some codes of conduct and local laws. And the French, when the first 2 decades they came to Cambodia, and they found the laws. They found the local laws.
Yes.
And they brought back to front because some scholars, when they went to front, they saw a lot of copies of law during the 18th and 19th centuries.
Yeah.
When the French they constructed, designed law for Cambodia, they spend some time to study the local laws. They
Yes.
try to modify,
Yes.
because the code of conduct for female written by King was very famous.
Yeah.
Did the French, I mean,
They studied what they called the Quran, and I think there were about 12 Quran that they had been translated mainly by the Clerc. And apparently there was a lot of criticism now of some of his translations, but it was his translations that they based their understanding of Cambodian law on. So I don't think they looked at things like the Jabab Saray, but they did talk about custom a little bit when they were looking at issues of divorce or what we would call family law, inheritance, that sort of thing. But they also had their own very patriarchal views of the family at that stage. So there's some argument, and I haven't gone into it in detail, but that the French actually left women with a lower legal standing in some respects than they had under traditional Cambodian law. I don't know whether that's true. I haven't studied it. Some people say that. So yeah, they tried to take Cambodian law into account, but particularly in criminal law and in procedure and in court structure, it was very much oriented towards French. Although they did continue to compromise, I think it was a political issue too. They even though they tried to take as much power as they could away from the king and the traditional elites in Cambodia, they ended up relying on them also to give legitimacy to their presence, and also they relied on them to administer a lot of their taxes and everything like that. So it was an interesting relationship. Yeah.
I want to know the make the Salakum and make they can try all the 30 often.
Yes. Yeah.
I thought he can issue the final judgment, and when they try all, they can separate about the trial judge and investigating judge. Okay,
so the May Kum first, this was an experiment between 1911 and 1922. In 1922 they abolished the judges, they abolished that judicial role for the May Kum, and they said it was partly because the May Kum, many at that time couldn't read or write, so it was impossible for them to apply written laws. But even during that time, their judicial power was quite small. I think they had the power to maybe fine people a little bit of money. And they were also meant to try to conciliate civil cases before they went to court. There was some appeal from the court, technically there could be appeal from those May Kum's decision, but only to the Court of Cassation, the very highest court. They couldn't go up to the next level. I think the second question was about the role of prosecutors, and is that what you were asking? Or?
About separate. They want to know the separate between trial of phase and
investigating phase. This procedure was gradually introduced. They started to do this in 1912 with their code of criminal instruction, as they called it, criminal investigation. But actually there weren't separate pre-trial, I don't know the terminology in Khmer, I'm sorry, but there weren't separate stages, separate courts for separate judges of investigation and judges of, how do you call them, judges? That started to be introduced in 1922, but mainly only in the higher courts. And it's something that I have to look into more. But it was mainly in 1922.
Okay. Any other questions?
I have one more question.
Yeah.
If you were to, I mean, I understand this is somewhat preliminary, you still
Yeah.
don't want to do. However, if you were to look into basically the roots of the Cambodian modern French legal system, which are this period in Europe, what would you say are some of the continuing legacies that have prevailed to this day? Considering, after all, the turmoil that has been.
Yeah. I think the fact that in terms of procedure and in criminal law, Cambodia still looks fairly much to the French civil law system. I think that that's one of the main legacies in terms of the substantive law these days. Modern law in Cambodia has been influenced by many different jurisdictions, as you probably know. It's been kind of donorized. So, the civil code and civil procedure code were drafted with assistance from JICA, so it's influenced by Japanese law, which is also a civil law system. The French helped to draft the new criminal code, criminal procedure code, so it's influenced by French law. But some gung-ho Anglos have also been there in drafting things like the land law.
Well, I'm thinking more of the institutional setting rather than the laws
Court
themselves.
structure. I think it's changed quite a bit. I mean, you still have your Salaga Bong. Some of the terminology, of course, is still the same. But there isn't now this what we call the Supreme Court now, the Salah. What's it called? It does both cassation and other forms of appeal. So that's been merged. It's still French influence, but not necessarily by the colonial French period. Mind you that the civil code that was enacted in 1920 was still in force until the new one was enacted about five or 6 years ago, because there was nothing under the Khmer Rouge like a civil code, nothing really under during the Vietnamese period. They went back to that one.
Thank you very much for
Thank
this.
you.
Thank you everyone for participation. And as I told you, we have a refreshment outside. So we spend some time over there or just grab some. Thank you.
Very good. Thank you very much. Yeah. Very well. Well, as you said, very well. Until it's done.
We speak about the